think they're gonna start and then I'm gonna send it out.
See you before. Cheers.
How are you?
I just told them we weren't sitting in the front.
How many we need?
Oh, Dolores is down there. We'll sit in the back.
Does she have seats for you?
Do you have room for all of us? Everybody's calling me. I'm popular.
I'll just save this one for Lori then.
Yeah, she's parking my car.
Laura.
They just got through saying they don't want
So it's gonna go around. Thank you.
I did.
Okay, if I can have your attention, please. We're going to call the meeting to order. And before we do anything, Lori's going to make a couple of announcements just in terms of how you can get more information, because we've already run out of pamphlets and so on. So.
We're going to pass around a clipboard, and if you put your name and email address, if there's anything that you wanted that we didn't have for handouts, we didn't know that there was going to be this many people here. And on the second part of the clipboard are the corrections that were done for the PA 490 land values, just to make it easier for some of the farms that didn't know that they got corrected. We did an approximate dollar amount, not taking into the fire districts. So that way, if you want to just look for your name, write down the amount, and then we'll go through the procedure in a little while.
Okay, thanks. So first of all, Donna's going to call the roll.
Chairman Tyler?
Here.
Vice Chair Lori Longhi?
Here.
Secretary Donna Dubanoski? Here. Everyone's here and accounted for.
Okay, next, we're going to ask everyone to please stand and pledge allegiance to the flag, which is off to the left. Thank you. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, the next item on the agenda was that we were going to discuss and or approve minutes, but there's so many of them to go through, and with such a crowd here, we're going to entertain a motion to table it, just to move on to stuff that people are really interested in.
I'll make a motion to table the minutes.
I'll second.
Okay, all in favor? Okay, so that's tabled. So the next item for discussion is the BAA reports on decisions of hearings that we held in 2022 for the 10-1-21 grand list, as well as hearings in 2023 for the 10-1-22 grand list, and its impact on houses, farms, and automobiles. Just a brief summary of all of those is we held over 700 appeals, and we heard them, deliberated on them, made decisions on them, and disposed of them within the past year and a half. There were only a handful of appeals that went to Superior Court after we were done, so we felt as though we accomplished our purpose. We tried to treat everyone with dignity and respect at the hearings, both last year and this year, and we're happy to say nobody's complained that we're aware of, other than the administration, but there's no taxpayers or citizens who complained. The next item on the agenda is a status of our request for a special meeting with the council. And again, I'm gonna breeze through this because I don't wanna belabor the point with things that are very technical, people might not understand, but for a little over a year, the BAA has been trying to meet with the town council in public in order to give them our view as to what the revaluation consisted of after we were done with all of our appeals, because we heard a lot of testimony, we got a lot of information that we wanted to pass on. But we've been frustrated in that for a multitude of reasons that I don't need to go into here, but anyway, we're hopeful that we'll be able to get a joint meeting with the council sometime very soon. We had proposed a date in August, but the town manager did let me know yesterday that that didn't fit with their schedule, so we're looking for another date now. And as soon as we do, we'd be in a position then to share with the council our response to the report that it got with regard to the revaluation. So the next item on the agenda is Donna and Lori, and they're reporting actually to the BAA on important taxpayer topics. The first topic that we think that will be very interesting and informative to all homeowners is the effective year built impact, or what we coined the fountain of youth manipulations of value and depreciation schedule. So with no further ado, I'm going to ask Donna to handle it.
Good evening, everyone. When I went before the council to talk about the BAA, we saw things on the field cards, or street cards, and we noticed the field called EYB, known as Effective Year Built, on the street cards. These are street cards over here, by the way. We dubbed it the creation of the fountain of youth formula, which was our words because it made properties get younger as they aged, even though no improvements had been made to the property. We saw the effective year or condition magically gets newer or younger. These changes artificially increase the assessment values. The report states that these conditions are based on physical observations made in the field by different data collectors. So it's basically a degree of subjectivity. Then goes on to say that the public needs to mention this to Vision or the assessor to have open communication. Well, I explained my personal street cards, which are these over here, during my interview, and how I went to Vision for a hearing on my home for the previous reevaluation. And that the Vision employee, who is still there today as the project manager, told me after that I explained my home and compared them to the surrounding homes on my street, and she looked at the data and said that she was not going to lower my assessment, but she'd raise my neighbors. Now, to say the least, I was surprised by the comment. I said that I wasn't here to discuss raising my neighbors, but I now understand why people come to the BAA upset with their Vision hearings. She said, the BAA? You didn't tell me you were a member of the BAA. And she was furious that I had not told her that I was a member. And I should have told her that from the very beginning. I told her that I came as a resident and not the chairman of the BAA. She left the room, went into the assessor's office, and came back and said, I'm not lowering yours, but I'll raise your neighbors. I told her that was not why I'd come in, and said something like, I was disappointed and to have a nice day. And after what I experienced, I really did understand firsthand how the residents felt over the past 10 years when they've said that their hearing didn't go well with vision. We also discussed in our BAA report, when this all started, that there was retaliation as a part of the past reevaluation. So as you can see on my cards, the print date is 8/10/19, and it shows my old style kitchen and my effective year built as 1984. The next print date is 8/11/19, and it shows the change to my street card by changing my kitchen from old style to average and my home effective year built to 1989. So it increased 10 years versus the 5 years that they keep doing in a reval year. This changing of the date, making the house younger, is why we named it the Fountain of Youth, meaning my house after meeting with vision was younger, and therefore my assessment after the changes to the kitchen and the EYB went up an additional $2,000 assessment, and I feel that was retaliation. Now, that worked out to about $80 more a year in taxes to me, and it's still being overassessed because my kitchen is still old style and the house is still built in 1963. So we pointed all these fields out on the card, and if they make changes, it affects the taxpayer. The report says the effective year built field, that other towns suppress this field. Not everyone understands what the effective year is, and it confuses them or it muddies the waters. I went and had my street card printed from the assessor's office dated 3/17/22. You see that the effective year built is there. And then after our meeting with the town council on June 5th, and we discussed the effective year built being the Fountain of Youth, I go down to the town assessor's office on June 7th, 2022, and the effective year built was suppressed. Poof, it was gone. We, the BAA, were saying, hey, this was on our field cards. We saw this issue, we spoke about it, and all of a sudden that information disappears because it's suppressed. The report saying other towns suppress it, so we should too. We never suppressed it in the past, and now the BAA has exposed it, and it's gone. So you need to go to the assessor's office for your card, and everyone, you need to know that the cards online are not the same as they are in the assessor's office. And the old cards should still have the data in the EYB fields. The best yet in the report is the footnote in the report where it minimizes the financial impact on taxpayers by stating the difference between average and good is only 5%. Only 5%, so Enfield, on a $300,000 house, 5% is $15,000. Enfield taxpayers are systematically overtaxed by Vision Government Solution. We think this is a very big deal to Enfield taxpayers. In conclusion, what we said about the Fountain of Youth formula and the effective year built was correct. And when Vision's project manager was asked during her interview, does the effective year built have an effect on the value? Her immediate answer was yes, because it does. Lori's going to explain depreciation.
Good evening, Lori Longhi. We stated in our report that we felt Vision's report was a little more than flawed. Depreciation is an integral part of how you determine value. The cost approach is on every field card with a building on it in Enfield. When we first went to the town council, I brought this example of a commercial property, and I had put some handouts out there, and if anybody would like a copy of any of the handouts, we'll be more than happy to get them to you. This commercial property had some changes on the effective year and the condition. And we thought that this was a manipulation of numbers because during the hearing, it was asked if there was any improvements done on the building, inside or out, and they had said no, absolutely nothing. It resulted in an increase of this property of $26,000 to the property, but no actual improvements were done to the building. A couple of days later, we mentioned this in the public, and then these fields were suddenly suppressed from every field card in Enfield. So you just couldn't see them anymore. These fields have been on our cards for years and years. And at the time, we were still in the window for court appeals. Now, you just can't find it You can't see it, you can't figure it out. Is this possible to do? Yes. It can be done with a click of a button. But should it be done? No. The assessors claimed that the information muddied the waters or people just don't understand it. Effective year bill and condition does affect your value, as Donna was explaining about the Fountain of Youth. The actual depreciation formula is in a handout that I left over on the wall. I left it so that people could look at it, and I will briefly go over it. Replacement or reproduction costs minus depreciation plus your site equals a value. Part of this formula is depreciation. Depreciation can be physical, functional, or external. And external people don't understand. It could be you live next door to the dump, you could live next door to a highway. There could be something outside of the factor of your lot that would affect the value of your lot. So that would be something external. Depreciation can be curable or non-curable. Non-curable is they're not moving the dump. Curable would be your house is dated, but you can renovate it. A structure's effective age reflects the quality of construction, the degree of maintenance, and it receives over the years with remodeling, etc. The effective age divided by the total economic life equals depreciation. Depreciation is the loss in property value from any cause. Doesn't matter what it is. That's what the answer is. Effective age is an important component of the formula to arrive at depreciation. Depreciation does affect property values, and that is the point that we were trying to make.
Before they go on to the next topic, I did want to let everybody know that we supposedly were going to have a meeting a couple of weeks ago, and our attorney made a statement. We didn't participate in it, and part of the reason was they were going to discuss individual taxpayers' files or appeals without discussing with the taxpayer that your files could be dissected in public. So before we started this tonight, I do want to let everybody know that every person we talk about or every file we talk about has already been reviewed with the taxpayer owner to make sure we have their permission and consent to go ahead and discuss it in public. There were several who were queasy, and so we said, well, that's fine. We have plenty to go by, so we are not, well, we're abiding by their wishes. And so far as the law goes, the law says we can talk about anybody's, it's all public and so on. We also think there's some things that you could do that you shouldn't do, and we felt that this is the right way to handle it. So just so y'all know, whoever we're talking about tonight, we have their permission and consent. Okay, thank you. The next item is going to be Donna on talking about local realtor or brokers.
There is a statement in the vision manual that says the next step is to identify the neighborhood street index and establish the corresponding boundaries associated with each. This determination is influenced by interviews with knowledgeable local brokers and real estate agents. Local sales data is collected specific to each neighborhood examined. We said this statement is false and misleading. They never contacted any local brokers or agents. They contacted one agent in Wallingford. That agent never had a sale in Enfield or North Central area. All she could do was MLS searches. I brought this up in my investigation, and the report's response is the BAA was mostly unfounded. I don't know how. The vision and the assessor say local brokers aren't necessary. Information is available through other media. The reports regarding the unfounded statement goes on to say that vision statement was false and misleading. However, it didn't affect the mass appraisal. So what we said was true. They did not need local brokers because they were relying on the assessor, the assistant assessor, for the knowledge of property owners, transactions, and in general sense, its real estate markets. The report said moving forward, Vision should remove this statement from the manual. As a local realtor for the past 23 years, I cannot disagree more with that statement. Lo and behold, neither can Vision. The project manager did admit in her interview that there are unique transactions where local knowledge and input is useful and in rare instances necessary. In my eyes, they are definitely necessary to get the correct land values, as local agents know our market. Lori brought this up in her to the investigator, that we noticed that there was an issue with neighborhoods that were used. Yet the report says the BAA was mostly unfounded and that Vision should remove the statement from their manual instead of doing it. How important is it that they contact local brokers? Extremely important, because it affected all the land values in town.
We're gonna make a motion to take a speaker out of order because she has another event to go.
Okay, I'll make the motion.
I'll second.
Okay, all in favor?
Aye.
Okay. Motion carries. We're gonna ask, we're privileged tonight to have Joan Nichols with us, if Joan would care to come up. She's the executive director of the Connecticut Farm Bureau, and she has some comments she'd like to make. But in addition to being executive director of the Farm Bureau, I'm familiar with Joan in terms of her having a very distinguished career also as an attorney and as a trial lawyer with regard to. She wasn't?
Nope, I'm not an attorney.
Okay.
Just act
I
like
thought you were a
one.
lawyer.
No, I just act like one.
Okay, well, I take that back, but anyway, so she's executive director of the Farm Bureau, and without any further ado, I'll have her as one of the guest speakers go out of order because she's got another meeting she's gonna go to.
I
Thank
talk
you.
really loud. Can people hear me in the back?
Yes.
Okay. If you want me to use the mic, I'll use the mic. I just don't want to blast you out of the room.
And then you can come back.
Okay, so I guess I'm a woman in demand because I have to be at an Ellington farmer event as well via Zoom. So if I cut this short, I'll be back in. So what the BAA has asked me to speak on are those farm properties that were terminated. So the best that I can tell you is that when the statutes were written in 1963 and approved by the General Assembly, at the time there were a lot of farmers on the General Assembly. So they wrote the statutes so that the average Connecticut citizen could understand them. They're not difficult to understand. So there has been an issue with properties that had been granted the farmland classification by the previous assessor in the town of Enfield, had been classified that way for many, many, many years. Within those classifications, those 490 farmland classifications, is something called the farm unit. That's further defined in the definition of farmland, which includes all of your tillable acreage, your pastures, swamp, scrub, ledge, and woodland. So when a farmland piece of property is classified under 490, it's the whole unit. If the farm has tillable acreage, it's the tillable acreage goes in 490. If it's swamp, the swampland goes into 490. If it's woodland, the woodland gets assessed as woodland under 490. So what has happened apparently is there's been farmland that has been classified all these years and for whatever reason terminated, and there have been woodland as part of the farm unit where maybe some of the farms stayed in 490, but there was this discretionary opinion that the woodland should come out of 490. So all I'm going to tell you is there are 3 statutes that apply to this. One is the Declaration of Policy, which is section 12-107A, which basically speaks to the intent of 490, which is to assess land for its current usage and not highest and best value, so that we can protect our working farmland and our natural resources for everything that 490 does for us. More importantly is 12-107B, which is the definition of farmland, which includes the term farmland, quote unquote, means any tract or tracts of land, including woodland and wasteland constituting a farm unit. Not difficult to understand. The last and most important part of this is 12-504H, and it speaks in the statutes termination of classification as farm, forest, open space, or maritime heritage land. In the statute, it says, any such land which has been classified by a record owner shall remain so classified without the filing of any new application subsequent to the provisions, and then it goes on basically to reference the 4 different classifications, until either of the following shall occur. Number 1, the use of such land is changed to a use other than that described in the application for the existing classification by said record owner, or 2, such land is sold or transferred by such record owner. It's not hard to understand. If the land has been classified as 490 farmland by the owner and by the assessor, and there's been no change in use of that land, meaning it's still being used for farming, the swamp is still the swamp, the woods are still the woods, it stays in 490. There is no provision in the statutes for reapplication unless there's a change in title or change in use, and there's no provision for termination by the assessor unless the title has been changed or the use has been changed. So when you have woodland and it was classified as woodland, if it's still woods, it stays woods. The only thing that happens with farms, and those of you that are farming, and I see many of you in the room that I'm familiar with, if you change, you go from tillable acreage and you turn all of that into an orchard, at some point you may want to change the classification from tillable to orchard, or from pasture to tillable, but it's still farmland. You put an updated application in, you say I have more tillable acreage, or I'm now using it for pasture or orchard, but it's still farmland. It's not a new application, it's an amendment to your existing classification. Nothing changes, nothing gets terminated. So with that, I am going to zoom into the town of Ellington, and then I'm happy to come back to answer questions or go into this further. Thank you.
Thank you.
Thank you, Joan, and we will want you back for question and answer.
I shall be back.
Okay. I'm going to go over the 78 farms that had corrections in the 2021 grand list and explain what actually happened. In 2020, the state of Connecticut issued new recommended land values for PA 490 properties. We were handed this list by the assistant assessor, and she said, use these numbers on this list. So in fact, we used those numbers that were on that list. We did not know until the following year when one of the local farmers brought it to our attention in a hearing that those values were at 100% and we had not adjusted for the 70%, and so therefore we overcharged all of the farms in their land classes by 30%. So we decided at that point that we were going to go through every one of the farm properties that this affected, and we were going to notice that we made the correct, a clerical error, and that the corrections had to be made to the 2021 grand list. We put it in our meeting minutes on April 26th, and we listed the farms that were affected and the amount that they were affected by. But then we learned that most of the farmers were not aware that this had happened to them, and that they don't really go to the minutes and look at the individual properties. So we wanted to make sure that we brought that up tonight. So we did pass along a clipboard, and we did have some of the names of the farms, and we did start to figure out the actual dollar amount, and I wanted to just go over the way to figure it out so that people could figure it out on their own. So if you took the credit amount and you divided it by 1,000, then that would equal the amount. But then you would have to take that amount and you have to times it by the mill rate, and the mill rate for those 2 years was 34.23. And that gives you the approximate refund, because we really didn't know where the fire district taxes or the properties were in. So we also found out that the town usually doesn't just give the refunds, you have to request the refunds. So you would have to go to the Town of Enfield page, and under departments, go to the assessor's department and go to forms, and then scroll to the tax office forms. And then there's a form that calls the request for a refund of property taxes. And so Donna actually did a spreadsheet, so we'll leave it up for anybody that wants to look at it after. It'll give you an approximate dollar amount of what those corrections should be. And if you have any questions, you can see us after.
Okay, actually also, there were 78 overassessment corrections for farms on the 10-1-21 grand list, but there's another 49 from the 10-1-22 grand list. So just in case any of the farmers are here, or you know of farmers that have been in to see us, they may have been overassessed and should look it up, because they do have money coming. I can't take questions now, we'll take them at the end though, okay? Here you go, Laurie.
Okay, I'm gonna be going over the development right restricted farm. To further clarify the BAA's statement on our report of May 28th of 2022, I would like to show you one of the set of cards that I presented to the investigator that I actually saw issues with. This was a 29-acre development right restricted farm. For anyone who does not know what that is, it's a property that can only be farmed. It's restricted by deed to agriculture, and the parcel is really limited to farming only. What I saw on the field cards during the hearing of this parcel was that the farm classifications had changed, the value had changed, and the audit trail had been turned off. In a 3-month time frame, this parcel value bounced all around. It went up over $1 million, no explanation, no support that I can see. On 12/15/21, the value was listed at $307,400. On 12/30/21, 15 days later, it was listed at $886,000. And on March 24th, 2022, that was the print date of that card, it was listed as $1,307.40. This parcel is landlocked with no buildings on it. If you take $1,307,040 an acre and divide it by 29 acres, it comes out to roughly around $45,000 an acre. This was a big red flag, because I appraise development right restricted parcels for a living, and I have done this for 20 years. I keep a database of them. The highest one sold in Connecticut that I had my database was approximately $20,000 an acre, and it was an equestrian center with buildings such as riding rings, horse stalls, etc. This 29-acre parcel is bare land, no buildings, and even at $886,000, it comes out to $30,000 an acre. And at $307,000, it comes out to $10,587 an acre, which is still higher than the average per acre value of development right restricted properties throughout the state of Connecticut. This was a very troubling thing, as we thought it was excessive valuation. I turned over these cards and all the documents below This is just one example that I gave the investigator. This is the pile I actually went through. This is what I gave the investigator to go through. I'm just explaining one of them today. To make things easier for them to review, I gave them the Connecticut Association of Assessing Officers Handbook with the pages that showed where I thought this property failed to follow the handbook. Okay? So, these were the areas that I felt. It failed on use value, pages 7 through 9. Legal factors, pages 7 through 9. The rule evaluation, pages 5 through 30. I gave a court case because the court case said you can't disregard the development sold on a parcel when you're doing evaluation. I thought it failed in uniformity, the same levels of values that should be throughout the thing, and as the audit trail in a revaluation should be turned on. In this particular one, it was turned off. So this print date here is the one that was 12/15/21. The value is $307,400. This print date, 15 days later, the value is $886,000. And this print date on March 24th, it's $307,040. But what I noticed was the audit trail. On this card down here, the audit trail numbers are all on there. And you can see who touched the card, and there's codes. Now, the one thing I don't know, because I'm not an assessor, I don't know what those codes are. But there's codes 20, 40, 41, 99, 30. I assume that they're some kind of a reference of what's going on in the file. This property changed in their classification. It was forest, had tillable B, had woodland. Up here it was tillable A. All things that we find that are not appropriate to do with farming. You're not supposed to be changing the classifications. This was one example of many that the farmers of Enfield were facing with the PA 490 properties. Note, if a property is removed from 490, you pay based upon the appraised values. If a farmer passes away, the estate calculates the taxes on the appraised values, not the use values. PA 490 farm sales are outside of the OPM ratio tests. No one is really looking at the farms. Were these properties increased when suddenly they were faced with removal of PA 490? This particular parcel is landlocked, doesn't have any road frontage. So they pay on the increased values. These were some of the concerns of the BAA. We saw imputed lot values, house lots that were just put on open farm land to increase the value of property. We had residential farms assessed as commercial properties to increase the value. We had reclassified tillable land on most of the farms in Enfield. We had woodlots removed from the farm unit. We had open space parcels removed after being in open space for 50 years in Enfield. We had restricted farmland valued much higher than the state averages. Your issues may have been individual to you, and you probably did not know that the others had these same issues. The BAA heard everything that you said in your testimony. These issues were just some of what the farming community faced and what we all thought was going to be investigated. We had seen other problems with house values, land, and autos. Tom will go over the 48 revisions next. Oh, autos, I'm sorry. I forgot about that.
That's okay, actually, they're gonna do autos next, but while Lori was testifying, or excuse me, explaining stuff, I thought I should explain also about her qualifications because she's a certified appraiser in the state of Connecticut, licensed on residential and commercial. She's also a home builder. She's a farmer, and God knows what else. But anyway, in terms of this revaluation, although Vision did so-called appraisals, there's no Vision worker that we're aware of who's licensed as an appraiser in the state of Connecticut. The only person who's licensed as an appraiser in the state of Connecticut, the town of Enfield is fortunate enough to have sitting on a board that actually understands residential and commercial values and how you get there, and that's Lori. So when she does talk, including all of the appeals we heard last year, we value her opinion more than anybody else's. There are times when other appellants would give us an appraisal from another appraiser, and actually we do put that appraiser and Lori on the same level in terms of as we're evaluating where each one's coming from. But anyway, that being said, I did want to comment on one other thing that before Joan got up there is Donna had talked about the no local realtors or brokers were consulted, and I think that what's important to know is Vision, when they got hired by the town, that's one of their linchpins is to say, well, we're going to talk to all the local brokers and realtors to find out what the status is and what's going on with the values in town. So they thought it was very important that they do that. There was a local realtor between the town hall and the assessor's office, so I don't know how many times they walked back and forth and nobody stopped there apparently and asked anyone. But what bothered us was when they said that the local brokers were consulted, and Donna asked, well, who's the local broker? And you find out it's somebody from Wallingford who hasn't done a closing up here north of Hartford. So we thought that's a big deal. And again, the reason we think it's a big deal is if it's important when they're going to do this report and they're getting paid for doing that, then why is it not important now that it's not included? And in fact, it was just false and misleading. We found it was false and misleading, and the report actually concurred with that too. So we just think that somebody besides the Board of Assessment Appeals should be monitoring what's going on with Vision as they are doing or not doing this stuff. And we think somebody dropped the ball on that also. So that's one of the reasons it's so important. The other thing I wanted to comment on is, I'm not sure people really understood this suppression thing. Because again, the town pays a lot of money to get all sorts of computerized equipment to give us information to put on these assessor's cards. Then when they put them on the assessor's cards, they hit a button so that it's, as Donna said, poof, it's not there for you to look at. So if that's the case, then why are we spending all this money for that? And then the second part of it is the audit or tracing of changes is very important, because you can go back 50 years and look at some of these street cards from before, and you can see changes that were made by different assessors, and it's easy then to follow. And it's important because, you know, assessors aren't here forever. There's maybe been 5 or 6 prior to Todd, and going back 50 years when Grassmere, for example, was given its open space classification, and it's right on the street card. So when somebody is hitting the suppress button there, it raises a red flag to us in terms of what are they trying to cover up for any changes that are being made. We want more transparency, not less. We don't understand how come a lot of this information doesn't appear online, so that if you go online and look up your information, it's not necessarily all there. You go into the tax assessor's office, it's not necessarily there either, unless I guess you gotta ask them to unsuppress the button, because you're not dummies, and you wanna know what the information is, especially when the town's paying for all this information, and then the people that are paying for it can't see it. It just seems wrong to us. But anyway, that's a couple comments. At this stage, we're gonna go into automobiles now with Donna and Laura. Thanks.
All right, automobile appeals are in September. If you have spoken with the assessor about your vehicle and still feel the assessment is too high, you must remember to pay the bill in July. And you can say that it is under protest if you want in the reason line on the check, but please pay the bill first. Then watch for the post on what days the September hearings will be. We post the date in August and we can't post it earlier. We have to wait 30 days prior to the hearings. There are usually 2 or 3 days that we do hearings. You do not schedule an appointment for the cars. It's first come, first served. In the past, the first hour has been the busiest. The form is online and we will have them available the day of the hearings. You need to bring the vehicle along with the backup documentation for any vehicle you are appealing. NADA and Kelly Blue Book are great resources as to the value. Condition, high mileage are some of the reasons to appeal. Classic cars are, which is any vehicle that is 20 years older, qualifies for antique plates. Some owners like vanity plates or don't want an antique plate, but the vehicle qualifies, and so they use the affidavit form to have the mechanic say that the vehicle is considered a classic car and is eligible for the $500 maximum assessment. Our new form is a little less consumer friendly and more onerous on the Enfield taxpayer compared to the rest of the state. The form says it must be completed in its entirety, and you may need to put a not applicable in the mechanic license section because mechanics don't have a license in the state of Connecticut. And either way, the new form has created one new barrier for the taxpayer and extra steps. The CAAO, the Connecticut Association of Assessing Officers, has a form that they put out for assessors to use. It doesn't require a notary or no mechanic needed, and it's one-page affidavit. The owner fills it out. It's simple. It's not necessarily a state statute, but it is most likely the preference of the assessor on what forms we use. So should you be denied for any reason on your reason, your option is to come to the BAA and appeal it. Thank you.
Okay, the next thing on our agenda is about the 48 reversals or revisions by the assessor and its impact on taxpayers. And I want to explain to people the process, because the assessor sets a value, you get notified, and then you have an option to appeal to the Board of Assessment Appeals. You then have a hearing, we present evidence, we deliberate, and then we make a decision. The burden of proof is on the taxpayer in Connecticut, but the burden is not a heavy burden. It's not beyond a reasonable doubt. It's a mere preponderance of the evidence. So it's more likely than not that you're right. But needless to say, if it's a tie, and I know one of the councilmen has been saying the tie should go to the taxpayer. Actually, in our situation, unfortunately, tie goes to the town. It does not go to the taxpayer. But anyway, so what happens is, as you'll see, our board, we're non-partisan. So there's 2 Democrats sitting up here and 1 Republican. When people come before us, we don't ask anybody whether you're a Republican, a Democrat, a socialist, whatever you may be. It just doesn't matter to us. All that matters is you're a taxpayer, you have an interest in the property, you have an interest in the appeal, and we treat everybody the same. So with dignity and respect. So once we've made our decision, then if you're unhappy with the decision, then you can take an appeal to Superior Court. You go to before a Superior Court judge and have a hearing and trial, and then they make a decision there. Once that's done, then let's say you got denied, you go to court, Superior Court judge finds that you should have won. The judge then enters a court order and sends it back to Enfield and tells the assessor to make a change or a revision on the decision that's been made in your case. So the assessor, there's a statute that allows the assessor to make changes under certain circumstances from our decisions. And that's one I just told you about, is the court order. The second one is in the event of a clerical error, and for instance, we added something wrong or subtracted something wrong. Either way, they should make the change, whether it's for the benefit of the taxpayer or the benefit of the town. We want it to be done correctly. The state statute says clerical error, assessor should go ahead and make that change. The third part where changes are allowable is in the event that your property, you take out a building permit, you build an addition to your property, well then there's gonna be a change to value because you got the addition on it. And the fourth one is something that's deleted from your value in the event that you demolish a building on your property. Well, then you show the assessor that you've demolished it, it's no longer there, so that value is then taken away from your property. So those are the four reasons under which the statute allows the assessor to do revisions. And I'm gonna let Carol Hall eventually talk about the rest of that, because it's gonna lead into what's happened, but we this year got 48 reversals or revisions that the assessor gave us based upon our decisions last year. And I believe that number of 48, for the reasons he gave, is more than the other 168 towns in the whole state of Connecticut put together. So what appeared to us is that what was going on was that that the tax assessor appeared to be somewhat suspiciously motivated because he had experienced a negative initial interaction with taxpayers the preceding year when he would show up on their private property without permission or consent. And then the owners a lot of the owners would ask him to leave and then reschedule a more convenient time. And it appears as though that irritated him and caused him to, we think, abuse his discretion in revising 48 of our decisions. Some of the examples of where he made changes that we've discussed with people and are allowing us to use their name tonight. One was Kogut, with Brian Kogut, who's here this evening also. And insofar as Kogut went, as I described that situation with Todd showing up on the property, now I'm not saying he's doing anything nefarious, not over there 2 in the morning, breaking in or anything, but still, just to show up on someone's private property without permission and consent. And Brian didn't know who it was, so he asked him to leave. And then subsequent to that, Todd removed and changed farmland classification at Kogut Farms. He then added 5 barns on a street card, portraying them as being built in 2021, which was basically new. And so what happened is the BAA, as part of what we do also, is if a taxpayer asks us, we go and inspect. So with this particular one, Lori, I believe, went and did the inspection at the request of Mr. Kogut. And in going over there, first of all, had permission from Brian to, otherwise we don't go on the property. So this new BAA inspection revealed that these barns actually were built in the 1960s. They weren't new. And they appear on all the aerial maps going back 50 years. Todd also claimed that some were constructed with wood when a BAA inspection revealed it was actually particle board, not wood. And of course, those would make changes to your value. The other thing that happened is that, with regard to Kogut, is that there was a house that Todd asked to inspect on demand, and he was told, leave. So subsequently, what he did is Todd added square footage to the basement of this house, then made the house look younger by changing effective year built from 77 to 1982. And then he improved the condition of the property from 4 to average on the street card. So once again, Lori went over at Mr. Kogut's request, did an investigation, and from the street actually could tell there actually was no house basement. So we don't know how that square footage got added when there in fact is no house basement. Then did an inside inspection and confirmed its poor condition. So what happened after that is the BAA granted Kogut's appeal for the 10-1-21 grand list. And that then was reversed by Todd in one of these revisions that I'm talking about now, one of the 48. So on the 10-1-22 grant list, Brian Kogut was forced to come back again, go through the same story again, do the same inspection again to show that nothing had changed from the year before. So he then, the BAA granted his appeal again. But this merry-go-round, it just continues for 48 taxpayers. And it's just not so merry for the taxpayers. It's not merry for us. And we think it's wrong. So this should not be going on every year. This process has got to be corrected. The other incident that we think may have led as an incentive to change some of these things negatively for Brian was, it was Brian Kogut who discovered the clerical error that was made the preceding year that Longhi and Donna, talked about for the farmers. And so we recalculated 79 farms in 2021, another 48 in 2022. And these farmers are due refunds. Now, when we finished all of our decisions, I brought them over to the tax assessor's office, filed them with them, and I asked that did they discover, or when did they discover, if at all, that we had made this clerical error? And I was told they had discovered it the year before. So when we filed it the year before, they knew there was a clerical error and did nothing to correct it. They didn't tell us, they didn't tell the farmers, and if it weren't for Brian Kogut, we still wouldn't know what's going on. But the other part of this, of course, is that no repayments were made to any of the farmers yet, and that's why Lori and Donna have gone the extra mile to try and assist the farmers in at least finding out what's happened to their property and requesting these that the town issue the refunds. And I know there are some council people here today. We are thankful that you're here to listen, and perhaps maybe there's some changes that can be made, because if the taxpayer was late on making a payment, I'm sure the town would notify. And it ought to be the other way around too, where the town notifies people for that. The other matter that happened with regard to these is a individual, just residential homeowner named Scott and Kim DeLorge. I know Scott's here tonight, and he's given me permission also to release his information. And so what happened with Scott is he came to us, the Board of Assessment Appeals, made a compelling argument, produced documents, and we granted his appeal. That was for 2021 and last year. And then Mr. DeLorge was unhappy with the fact that the assessor had been over his property, and even though it's posted no trespassing, and Mr. DeLorge had seen him on the property, doesn't know who he is, and they had some words. So Scott then went to the town council, public participation, complained to the council, let them know what's going on. And we believe subsequent to that the assessor then made some changes. For instance, I believe, I'm not positive in this because I don't have the card in front of me, but from what I understand is he changed the garage to a pool house or a cabana, which increases value. He then increased the pool size, changed it to a heated pool, which it isn't, and he removed the farmland exemption, which we had restored. So he did that to the streetcar, which grossly increases the assessment to the taxpayers. This is one where Councilman Nelson actually, at one of the town council meetings, asked the report's author to investigate and report back to him whether or not such changes were properly or improperly made by the assessor. And to my knowledge, there's been no written report back yet, but I'm sure Councilman Nelson will be following through on his request to find out what the scoop is on that. And then the third one I want to tell you about is Trinity Farms, who's here also, the Smith family. And for those that don't know it, the Smith family has been here in town probably as long as the Jarmock family. And the fact that they are being targeted is really personally upsetting. I'm a native, Laura's a native, Donna's a native. We know all these people. We know we know Michael Smith's father. Michael was friends with my sister-in-law years ago. We know all of the Smiths are just pillars of the community and have been. So with regard to Trinity Farms, here's their story is, that the assessor improperly classifies them, and if anybody knows where Trinity Farms is, as a commercial enterprise, like H.P. Hood and Son, over in Des Moines. That's his words, not mine. And then that was contradicted by a Connecticut Farm Bureau opinion by Joan, who's left here. But in addition, the Smiths went the extra mile and asked the Department of Agriculture to do a site inspection. They did a site inspection and concluded it's farmland, it's not commercial. And the Commissioner of Agriculture himself wrote an opinion letter with regard to Trinity Farms that was presented to us at the BAA. So we have common sense, and we have what's commercial, if you've ever seen the inside of their store, and what's a farm. But even more disconcerting to me personally was that, again, they asked for a BAA person to go out and inspect, and Lori did the inspection, and what she found was that they have one single farm building that's being assessed and taxed on 2 separate parcels. So they have one farm building allegedly on one parcel being assessed fully and taxed, and the same building on another parcel being assessed and taxed. Now, I'm not blaming this assessor for that. I believe it was done maybe 8 years ago or so. However, what is troublesome is when they're doing a revaluation, if she can find it, then what are these revalue people doing? Because they should know that you don't tax on 2 parcels. So when we rendered our report with the assessor, we actually made a special resolution on that to let them know what happened and why. And so, make the correction, put it only on 1 parcel. We named which parcel to put it on, leave it off of the other one for agricultural reasons. And then the family should have, gotten their refund. But from what I understand, the refund that should have come with a sincere apology and regrets has still not even come yet. And they've had difficulty trying to get their refund. This has got to be corrected. It's just wrong. And so with that, that's our story on the 48 revisions or reversals that we're on.
Sorry.
So, it's funny, usually I have that effect on women that are older. Oh, well, it's time for, as my wife would say, Tom, stand up, speak up, sit down, and shut up. With nothing further to do, I'd like to introduce State Representative Carol Hall, who really was stalwart in trying to get a bill passed to correct the situation now so that these 48 revisions don't keep coming around again. So, Carol, here you go.
Thanks, Tom. I have some notes, so I am gonna try to stand up here with my notes. So, first I'd like to thank the BAA for hosting this forum tonight, this meeting, and for the invite. And first and foremost, I think we need a big thank you to this group that's endured the last 3 years and has done an amazing job. I think Tom touched on their qualifications a little bit, but what a lot of people in this room don't know is the BAA is an appointed position throughout the state. And what happens is you can get BAAs together that actually have very little knowledge of values and statutes, and we are truly blessed to have 3 well-qualified people sitting up here because a lot of the towns throughout the state don't have what we have here. So we are lucky to have a very well-qualified, well-educated, and well-respected BAA in our town. So I personally want to thank you all for all the time and dedication you've put in especially over the last few years that have been very tumultuous, to say the very least. So I'm going to start first and talk about, Tom talked a little bit and Lori and Donna talked a little bit about the process. But I think what's so important in the bill that we actually passed, a lot of you might know, it's 6893. It was passed by the state legislature unanimously. So the Senate voted 100%, the House voted 100%, and the governor vetoed the bill, which is highly unusual, to say the very least. And basically, I'm gonna get into the meat and potatoes of the bill a little bit, but just to go on what Tom talked a little bit about, the process for your BAA appeals are always linear, right? So you start with the assessor's office, you can go in and ask them to take a look at your assessment and plead your case to them, and they have the right to go in and go, okay, yeah, it makes sense to me, I'll adjust it. If you get no satisfaction at that level, your next option is the BAA. So going from the BAA, let's say they don't find in favor for you, you next can take your case to the Superior Court. So you have an upward mobility with your appeals, right? So what's been going on in Enfield is a merry-go-round, a dog chasing a tail. That is not what our state statute sets forth. So your appeals go upward and always onward. They don't go in a circle. So what our bill actually tried to do was clarify the statute a little bit. And Tom talked about the statute and where in the statute the town assessor actually has the power to go in and change the values. And he touched on all four of them, but I'm gonna talk about them a little bit because they're important to the change that we actually made in the legislature. So the town assessor has 4 reasons to go in and change your assessment. Tom talked about them. A court order, you won your appeal when you took it to the court. The second one is to reflect an addition, a change, a new bathroom, a new room, whatever you've done, material changes to your property. The assessor can go in and change your assessment. To reflect damage or demolition, so not only full demolition, but a fire, a flood, changes the value of your property. So it allows the assessor to go in and again, take your value down, which you would expect. These are all common sense things, right? The last one is the correction of factual error. So what seems to be the confusing part of the statute for Enfield anyway, 168 other towns seem to understand the state statute. But for some reason in Enfield, there's 3 words in the statute that our assessor is hanging his understanding of his powers on, and that is in the statute on line 68, it talks about any other reason. Now, I think there's a lot of attorneys in the room, I see a few, they can tell you that you can't take a statute and read 3 words out of the statute to understand the statute. That's not how we read statutes. What this statute talks to is the original 4 things that Attorney Tyler talked about. His confines for making changes to anybody's assessment, whether it goes back and changes the BAA's determination or any other time. You go in, you've just built a new house, there are confines that he has to operate within. And those are all in this statute. So what we did in the legislature, we were like, okay, it doesn't seem that this problem is being taken care of administratively. So that's one thing, we agree with what the governor said in his veto. This is a local issue, it should be taken care of administratively. 100%, we all agree with that. It's a simple solution. But it wasn't. So then it takes the next step to the legislature. So that's when we step in and we go, okay, how can we clarify this statute? How can we get this one town that doesn't seem to understand the statute to understand the statute? So we went on to further explain the statute, and we added 3 lines to the end of the description in this particular section. And basically it read, no assessor shall increase or decrease any gross assessment prior to the next reevaluation for any reason other than those set forth in paragraph A through D. So basically what we did in this, we didn't change the law, we didn't take powers away from the assessor, we defined the statute as it sits now. The entire Senate agreed with this interpretation, the entire House agreed. And it's basically when you stand up and you argue and both houses agree 100%, believe me, it's a rarity. It really is. So it seems like when you talk about both chambers on the same page, they're spelling out the legislative intent of the statute. Yes, we agree with the way it's written. This is what the interpretation of the statute is. Unfortunately, the governor, in his letter of release, like I said before, we agree with one thing, that it should have been taken care of legislatively. But he goes on to explain in his veto letter that the Board of Assessment Appeals is a mediating board. So that's a fundamental misunderstanding of the statute to begin with. The BAA is not a mediating board. They do not sit down between the taxpayer and the assessor and mediate a solution. That is absolutely not their role. It's not what the statute says. So it's a shame there's a fundamental misunderstanding in that office of what the actual statute does. However, what I will say is, for both colleagues of mine from both sides of the aisle agreeing with the BAA and their assessment of this statute, it says a lot. So I think we had so many complaints, and that's what's generated this bill. And the fact that this bill got through both chambers is amazing, and it was 100% on both chambers. So I want to say thank you to the BAA for all their hard work, but I also want to say that if this isn't resolved administratively, this legislation will move forward again next year. I guarantee you it will make it through both chambers with 100% vote once again. But what we will do next year is we will sit down with the Board of Assessors Association, and they were involved in this, by the way. It seems like the governor's office felt that they weren't consulted. We actually did talk to their lobbyist quite extensively about these changes. So with the adjustments and the definitions we added to the statute, all their concerns were actually heard in what we did. So next year we'll sit down, we'll spell out anything they feel needs to be added to make a further clarification. We're happy to work with them. But the way the statute is written now, the assessor has those 4 reasons, and that is it. They're tight guidelines, and hopefully next year we're not in the same place and it's already been taken care of. But we'll see. And I just want to beg your indulgence for 1 second, because I just want to make a personal comment. So as a taxpayer and a former town councilor for 13 years, I sat in those chairs, and I actually listened to the investigation report very closely. And I actually watched it twice, because the first time I was kind of in awe of some of the things that were said. But the second time I jotted down some notes, and I think they're important to put on the record here today. So as you're sitting listening to the report, I made notes on specifically what were said about the assessor from the group that all of you paid for in this room. So you, me, everybody sitting in this room today paid for this report, right? So I'm listening, and I'm listening to him talk about the tax assessor and say, these are quotes, well, maybe he didn't use best practices. That's one quote. Second quote, and this was alarming to me, and my husband, who was in the room at the same time, and many of you know him, he's been in law enforcement for 35 years, his ears perked up when the next quote was, well, he mostly complied with the law. So at that point, my husband actually turned to me and said, what did he just say? I don't think I'm divulging any home secrets here. And then the next quote was, well, he generally complied with the law. Another quote, yes, he used aggressive practices. And the last quote was, yeah, could have used better judgment. To me, I think what alarms me the most is when I sat in those chairs for 13 years, the standards of our town employees would never have been acceptable for somebody to mostly follow the law. It's mind-boggling when you listen to the person that we paid to do this report make these commentaries. These are quotes, they're not made up. You can all go and listen to the report for yourself. But we have great employees in this town. We have, I'm partial, I think we have the best employees in the state of Connecticut in this town that work very, very hard for each and every one of us. So we are blessed to have good employees. But these kind of standards are unacceptable to me as a taxpayer, and I would think to everybody else in this room. So, I'll close by just saying that I'm hoping that the town listens and heeds the governor's opinion that this should be handled locally and at the administrative level. If it doesn't, we will be back next year with the same changes to the legislation to further define, so it's clearer that the assessor does not have the power to overturn the BAA's decisions just on a whim. So I thank you all for your indulgence for going through all that. It was a lot to unpack, but I think we've all lived through a couple of years that have been extremely difficult for our taxpayers and very disappointing. And I can honestly say in all the years that I've served, I've never seen anything like it. So, thank you. Yeah, thank you, everybody. Thank you for coming out tonight.
Thank you, Carol. Okay, so now at this stage, we're at the question and answer segment. Oh, Joan's back.
Yes.
Do you have anything more you want to say?
No, but I'm happy to answer.
Okay, yeah. So we're at the question and answer segment. However, what I want to suggest to people is that when you want to give us a question, all we require is that you're a taxpayer. We would prefer not to have a name associated with the question. It's all FOIable. So, we'd rather not have names attached with any of the questions. If they're written down, that's great.
And they can put them in the basket if they want.
Okay, we have some in the basket. While that's coming over, I did get one on the way in also. Thank you. And this was a question of, does anybody know how much it costs the town of Enfield for the report? So we don't know the answer, but there's enough council people here today that I'm sure they can try and find out from the administration where it is. I don't expect them to know off the top of their head either. And then,
Can I make a comment before you go to the question? I want everybody to know that these three here are volunteers. I mean, they have spent so much time the past year and a half. They're not paid, they do it all, they're doing this, do what's right. The other thing is that about for a year and a half ago, it was Councilor Ledwith who started ringing the bell about the problem. So he was the lone bell ringer, and I just wanted to point that out.
okay, thank you. We actually would prefer not to have anybody talk except with the questions coming from us, so it doesn't get out of hand. But anyway, first question, well, before you even do that, I did think of one thing that, for anybody here, you own a house, you want to find out what your street card looks like. So perhaps Donna or Lori can explain that again, unless you kind of know what you're doing. But, okay, so I'm going to ask Lori, that'll be question number one is, how do I get to find out what's on my street card? And I want to get it where I can get the buttons unsuppressed to find out what the scoop is. Because if you unsuppress them, you'll find out, as we did, when things are built like with Donna's, the different sequence when she's not doing anything with her house, but it seems to get younger and more valuable for assessment purposes. So maybe you can handle that?
So one thing is the town of Enfield has an online version of your field card, but they don't have the same information on there, and sometimes it's not updated. So I was just not using the online version and going right to the town hall and requesting your actual property card. But you would want the card for the current year, and you would probably want to ask for the reval year and subsequent years before that. So that's where you can tell the pattern of where things changed. If you don't have the previous cards, you're looking at a card, you really don't know if it's changed if you don't have anything to compare it to. Some other towns in Connecticut, because as I go to other towns, I'm an appraiser, their online version is actually the field card. So you don't have that issue of having two different informations. So unfortunately, you have to go to the annex department and request it. But then you really should be looking at it and ask if you can get the field card with the unsuppressed information on it. And if they won't take that and give it to you, go to those previous versions, at least get a couple of years so that you can see the progression of what your house is. So you know your property the best. You know if it's been renovated, you know if it's original, you know if you took out permits for a new roof and things like that. Those are all things that should eventually show up on the field card.
Okay, the next question we have is, open space is on our maps, and we had parcels in open space. Why were they removed? Well, I'm going to give this one to Lori also, because she's the appraiser that knows all about open spaces. Thanks.
All right, so we had quite a few appeals that were properties that had been in open space, some of them for as long as 50 years. They were done by prior assessors, like 5 assessors ago. So they got put in when our current assessor came into town. He said we didn't have open space in Enfield, and so he removed all the open space parcels that were on. I personally am not convinced that we didn't have open space in Enfield, but I don't know, it was not our job to go and do all the research of that, but we did come across a lot of research in the testimony and the documents that were given to us. We do know that open space was in our plan of conservation and development. We do know that parcels, those same parcels that got kicked out were mapped in the Department of Environmental Protection, as well as in our plan of conservation and development. We do know that CROG gave some opinions regarding open space in Enfield back in the 90s. I also, in this last round of reversals, requested from the assessor's department the old field cards on these parcels that got removed, because typically as part of like my appraisal process, I would want to see old cards to see, well, when did these parcels actually get put into open space? And I discovered that in their own records, these parcels actually had it said, placed into PA 490 open space 1976. But for some reason, we don't have open space in Enfield. But those questions have never been answered. So I, think that there could be some research done. It could have been done in the 60s, it could have been done in the 70s. I don't know. I don't know why the assessor 5 people ago placed these properties in open space, and now we don't have open space. But I do think that those are really serious questions that should be looked into. And so, in essence, the BAA voted to turn these parcels back into open space, but then they got reversed again, and so we're in the round robin. So, that's all I know about it.
There's one other aspect to this. Open space is different than other 490s in terms of they have a statute you're supposed to follow. However, in our looking at all the things that Lori said, which we did look at, there's also a doctrine in Connecticut called exceptions to the doctrine of equitable estoppel, which basically means if somebody comes in and they apply for open space in 1976, they're granted open space in 1976. So for the next 50 years, they're living with open space in 1976. And they have a right to rely on that, even if there was some technical issue with the law, perhaps. So we looked at that particular that doctrine, and felt that in terms of fundamental fairness to the people in this town, if you're relying on this, and it's been there 50 years, and you have 5 or 6 assessors previously, then we thought that you would, if you were denied, you would have recourse to the courts, you would have to spend some money. In the end, we felt you would probably win, in which case that cost the town more money, which costs all of us more money to do something that's not right. So that was the reason that we put a lot of these open spaces back in, because they of that doctrine of equitable estoppel and the exceptions to it. I'm not going to go into all this stuff now, but it's just, you get the drift. If you come in and you rely on something, and you're induced to rely on it, and the town induces you to rely on it, then they can't pull the rug out from under you without paying a heavy price. So that's the other partial answer to that. Oh, that's a good question. Okay, question here is, how much time do we have to get a refund? So.
The 2021 error that we made, you have until October 1st. Otherwise, he's going to tell you you can't get it. So make sure you go and get this taken care of before October 1st. That's the best I can tell you.
Are there any other questions? How about any questions for Joan or, yeah, okay. Well, you know what?
There was a couple other questions that we had on.
Without them, we already did them. Okay, I'm gonna try and, you tell me and then I'll say. Oh, no, wait. Excuse me. So what's the question? Okay, this is a question that's basically more of a request that the presentation that we just gave, then that there are a lot of councilmen here today that are interested in, and that's wonderful, but the question was, this should be shown to the other councilmen, and actually, when we do have this joint meeting, if it ever happens, that would be part of what we're gonna do, in addition to a lot more. This is, the reason we picked these topics is because we thought they're important for the citizens to understand what's going on, because BAA, when you talk about assessment appeals, I mean, and real estate and values, it's boring to a lot of people, but when it's your pocketbook and it's your house, and it's taxes, it's a lot more interesting. So we tried to make it so that it would fit individuals' residences as well as the farmers. But what we'll try to do is, we actually brought our own guy today to do the videotaping. But the reason was that on the internet, somebody was saying to the town manager, why don't you have this go on live stream and all that. And so her response was that she was under the impression that the BAA videotapes all of its meetings. We never videotaped any of our meetings. So, but it gave us an idea. So over the weekend, I did make a couple calls and geez, you know, that's not a bad idea. And then Lori asked the town manager if they would videotape it, live stream it on the town station. And the reply came back that they were unable to because too many people were on vacation. So that's okay, but, so then I made the call and said, you know what, then let's us do it, and then at least we'll have it. And I think what we'll do is, to answer the last gentleman's question, we'll provide the video to all the town council members, so then they can look at that at their leisure, and anybody else that wants it. I mean, I don't know where it appears. Do you know where it appears? When?
We'll find
Yeah,
out.
well, we'll find out, and so hopefully it does get some play with a lot of citizens that aren't here that will be interested in what you've learned and perhaps what you do to make things better. So anyway, okay. Who's going to explain to the governor what a BAA job is?
Lori.
All in favor? That was a good one. Okay, how do you ask for the refund? In writing? You got to.
Yes, there is a form.
Yes, we had some of the, okay. So
There
we
were-
had some of the forms here. That was the process that I was saying about the refunds. If you go to the Town of Enfield website, there is a form under the Assessor's Department, under tax forms. It's only tax form, it's requesting the money back. And from our understanding, clerical errors, this was a mistake, it was an error on our part. You can do this for up to 3 years. So we just don't want everybody to miss out on the fact that we made this error. We were handed the form and said to use these numbers. We used the numbers. I have to say too, when this was brought to my attention, that I quickly asked the assistant assessor while the applicant was in the room, and they knew about this error, but just chose not to tell us about it. So I looked at it as like, if it's one way for the town, they're trying to get the money. If it's the other way, they don't want to let you know about it. So we at least wanted to get it out there that we made this error, the BAA did this, and we're rectifying it. And we appreciate everything that the farmers brought to our attention, because we would not have known otherwise.
Okay, the next question about, is there a code of conduct for Enfield employees? I'm not qualified to answer that one, so probably gotta ask your councilman, and have the councilman get back to you, research it and get back to you, so. Are there any other, how about any questions for Carol or Joan while they're here?
Question for Carol, probably not up on my state government, but if you had that much support, couldn't you override that veto?
So the governor, let me just stand up, the governor vetoed 5 bills. The governor vetoed 5 bills, and what has to happen is the majority party has to make the decision to come in. And what was explained to us is that the majority party that holds obviously all the cards right now will not bring us in to correct the 5 vetoes that he did. So it's basically the ranking members of both chambers that make that call, and they decided against it.
I think next year, if she gets the bill in earlier and it gets passed and then gets vetoed, then at least they're in session. I think the problem is you're not in session when it came up. So next year, if you do it, well, and you couldn't do it, done it any earlier, because we didn't even know this issue until March had happened. And in fact, even then, when it happened, I did send a letter to the assessor, asking the assessor if he had any other reasons he could give me in terms of why they denied and reversed or revised these 48. And I specifically asked him, do you have any expert opinions? Like, do you have any attorneys, accountants, appraisers, or soil scientists that you relied upon and have any reports from in order to back up your decisions? And the answer that came back was that he did consult with a town attorney, but he didn't have any written legal opinions with regard to basically any of these appeals. And he didn't have any accountants. And we know the only appraiser is sitting here. So there was no appraiser that he had, and he's not a soil scientist. So that the changes he made with regard to soil classifications for farmers also hurt the farmers, because if he did, for example, let's say somebody's growing corn on their property, and that's, I'm going to say, tillable C. Then the guy next door is growing tobacco. Well, that's tillable A. Tillable A has a higher charge per acre than tillable C. So what Todd did is, he figured if the guy next door can do it, then you probably can do it also. So he was changing people's classifications based upon that, rather than a soil scientist. And so that's why we reversed all of those, then he's reversing them back, and so we'll probably be the same merry-go-round until this gets straightened out. But that is one of the other things that we did try to do to help short-circuit this. So are there any other questions? Yes?
Just like to make a comment that the street card is 2 pages.
Yes.
So make sure if they give you a copy, they give you 2 pages or both sides.
Right. Yes.
Okay, good point. Okay, if there
Oh yeah, big money.
any other, Joan? Yes.
50 cents a page. Yeah, I just,
Both sides is 1 page.
yeah, I just wanted to make a comment. You mentioned earlier about getting a copy of your field card for your house. The farmers should all get field cards for their properties as well. It's not just Enfield. Over the years I've gone over hundreds of field cards for farmers, and I find errors in those field cards, even in other towns. Sometimes the farmers didn't know that they should be breaking out the acreage, so they call it all tillable A, when in reality there's swamp, there's woods. So the one thing that the farmers do have control over, normally, is how your acreage is classified. And it's always good to go back and look at your field cards and make sure that it's appropriately classified for the footprint of the acreage on your farm. And also make sure, to your point, Tom, that acreage didn't get little feet and walk from tillable C to tillable A overnight. Somehow all of a sudden it got better, right? Just like your house got better. So it's worth, if you have not looked at your field cards, plus most farms also have a lot of infrastructure, buildings. You may be getting taxed on buildings that don't exist anymore, and farm buildings, and I don't want to get into farm buildings, but generally they depreciate, right, Lori? They don't appreciate. So you want to keep an eye on how your farm buildings are being assessed as well.
Joan, can you talk about the watchtower, like the fact that there was only those 4 reasons? Because it seemed as though in the investigation, it was giving a lot of leeway that's actually not accurate, and I'd like to have you clear that up.
Well, like I mentioned earlier, I'm not an attorney, so I actually never heard of the watchtower, so you told me this morning, Laura, I've never heard that term. I don't know how to answer that, I'm not an attorney, maybe, Tim could answer it, but anyhow, all I know is that the 490 statutes are pretty clear. And if he's using some other law to rebalance the grand list or whatever, I don't see how that overrides the 490 statutes. And you had mentioned in one of those in the report, there was one Supreme Court case. There's other Supreme Court cases very specific to 490. One of them, another one is Johnson versus the Board of Tax Review for the town of Fairfield. Also speaks to the fact that once it's classified, it cannot be terminated. So there's not just lower court cases, but there's Supreme Court cases. So again, I'm not a lawyer, but you not only have the statutes, but you have the court cases, and especially the upper court cases.
Thank you, Joan. I do want to use one thing up here, one of the posters that Lori did, because this was, we found in many of the farms. And again, on this particular one, the value of the property was $307,000 landlocked. A picture, all of the farmers, that a lot of them had their values jacked up with nothing new happening on the farm. And then finally it ends up to $1,307,000. But it was at that stage then that the farmers didn't really notice it because they're paying on the basis of per acre that OPM puts out, Office of Policy Management. So it would be a much lower assessment that they're paying their taxes on. However, when they got knocked out of 490, then they really weren't looking at this. They just knew they were knocked out of 490. So then when they came to the Board of Assessment Appeals, they're trying to get back into the 490, don't understand why we got knocked out. But there are a lot of farmers that did not come to see us, that didn't realize the impact of it. And what happens if these people didn't realize the impact and they're knocked out of 490, the next tax bill they got is not an OPM number on farmland. It's based on $1.3 million, which is a significant amount difference, especially for farmers that, well, hey, it's significant for everybody. But I'm just saying that it appears as though values were raised, well, values were manipulated and artificially raised to a certain level. Then they're knocked out of 490, so their eyes are looking at the 490, and they don't look at the other number, which is critical to them. And the other problem, of course, is when there is an estate, somebody passes away, then the IRS, the state are going to be looking for numbers in this range, the 1.3 million, not the 307,000. So now, with regard to your houses, virtually all the houses were subject to this fountain of youth, where your effective year built is different, your quality or your condition of the property is raised from average to good, and all of these things are done without your knowledge. You don't know what's going on with it. All of a sudden, then you get a tax bill, and the tax bill does not tell you, oh, by the way, this is how we got there. That's why it's so important. You go get your street cards. You want to get the street card from before the reval. That way it'll show you what it was, what it is now, and especially as in Donna's case, nothing's been done over there to justify any increase in the value based upon the condition of the property or effective year bill. And that's probably what we want to leave you with, so that you all understand that and can help protect yourself while we try to work through these problems together in the best interest of everybody in the town of Enfield. So we're gonna.
One more question.
Oh, you got another question? Okay.
Okay.
I don't know the answer to this, but I would think they should. The question is, does the tax assessor office have to provide unsuppressed street card when asked for it? I would think they have to, but I don't know for sure. I mean,
that would be a good question for
Yeah.
the council members to
yeah,
find out.
it's
I have another question. So,
Sure.
you can go online and go to Vision Appraisal and pull up your card.
Yeah.
Did you find a lot of discrepancy between the cards that you could just print offline, and if you went to the town hall and grabbed a card?
Yes,
Was there discrepancy in those?
There is some discrepancies, but the other thing is there's a lack of information on the cards that are online. You will not get any of the details. You do not see any of the details.
That's what I've been telling a lot of residents that have been following me on this, and I've been getting a lot of calls recently with the new tax increase, is I've said to them, go online, pull up your tax card, and then print it out, and then go to the town and see if there's a difference on it.
Right. There might be a delayed process with the online cards. The online cards sometimes are not updated as immediately as if something were to happen with a change. I'm not exactly sure what the process is in Enfield, Some towns do it immediately, some people adjust their cards every month. But I always say go down and get the actual street card, because that's where you're getting the detail. You're not getting the detail on the online versions. There's just so much information missing.
And tell them unsuppress the button, and then see if they do. If they do, they do. If they don't, then, you know,
Again,
gotta
I
find,
just,
gotta
I
find
know
somebody
you
else
can
to
get them
complain to.
online, and I
Yeah.
just wasn't sure.
Yeah. Okay, so are there any other questions? Okay, we're gonna, do our motion to adjourn, right?
I'll make a motion to adjourn.
I'll second it.
Okay, all in favor? Aye.